Welcome back to State of the Nation. 3 of the 4 pillars of the Constitution are under attack. The recent budget seeks to destroy property ownership, freedom of speech seems at daily risk, and now the rule of law is in the firing line as the government looks to restrict trial by jury. Determining innocence or guilt by a jury trial is an essential defence of freedom. The police, prosecutors and judges are all in the pay of the state, influenced by the culture of officialdom and led by members of the establishment. Starmer has good reason to dislike juries, for they humiliated him when he prosecuted 32 journalists as the Director of Public Prosecutions for the crime of receiving information from officials. Juries found them not guilty, and the final cases collapsed. But it was a concerted assault on the freedom of the press to prevent embarrassment for future governments, which was only seen off by jury trials. In the mood of the times, the establishment, the blob, was itching to find journalists guilty, and that included judges. Judges are not immune from political influence, and in recent years, activist judges have increasingly become more political. Baroness Hale, who consistently voted against the last Conservative government in the House of Lords once she'd retired, showed off about her political position by wearing a ridiculous brooch when overruling ministers. The recent tendency to replace ministerial decision-making with judicial opinion has inevitably politicised the judiciary and reduced trust, as they seem to belong to a left-wing ascendancy. Against this background, appointing Sir Brian Leveson to inquire into reducing trial by jury is like asking Judge Jeffreys to report on the Monmouth Rebellion. He has little reason to love juries, as he was famously embarrassed by the acquittal of Ken Dodd when he was the lead prosecutor, and he showed in his appalling free speech undermining eponymous report into the press that he is no lover of our ancient liberties. So you see a hatred of liberty to decide upon removing further liberties. Juries protect from an overmighty state, and judges are much less independent than 12 fellow citizens. Juries sometimes acquit against the evidence when they think the law itself is unjust. Judges do not do that. That is not their business. Judges claim to be uninfluenceable. But when the government wanted cases hurried up, as with those after the Southport riots, they fell over themselves to comply. Criminal prosecutions have become a feature of modern politics in allied, democratic, friendly countries. It was tried against Donald Trump and is being tried with Madame Le Pen. It could happen here, in which case the jury is our safeguard, as it proved itself to be in favour of freedom of speech against prosecutor Starmer a decade ago. As ever, let me know your views via mailmog@gbnews.com, but I'm very pleased to be joined now by Paul Britton, founder of Britton & Time Solicitors. Well, thank you very much for having me, coming in. It is very worrying that the answer to problems within the criminal justice system is let's restrict jury trials, which is the absolute bulwark of our freedom.
If that is the go-to, if that is the knee-jerk reaction, then yes, that's absolutely wrong. Because you have a right as a defendant in this country to be judged by your peers. That's one of the salient principles of criminal justice. And to take that away in favour of what we call swift justice. So swift justice is where you will go before a judge, the judge will hear the evidence, and then go on to the sentencing. When some people say that the judges have no power in the Crown Court, it's because they don't determine guilt. The jury determine guilt, and it's only for the judge to then issue sentencing. But no, short answer to your question is, if they are going to that as a go-to, that's the wrong thing to do.
And this seems to be where the process is looking to go, to have an intermediate step somewhere above a magistrate's court, but below the full Crown Court, where you'll have a judge and 2 magistrates sitting together so that it'll be quicker, and that this is seen as being a way of dealing with the backlog cheaply and quickly.
So it will be introducing a 3rd track. And actually, that's quite funny because in civil, we've actually just introduced a 4th track. But yes, to introduce a 3rd one would be dangerous. To deal with cases expeditiously and to look at the backlog. The backlog, you don't really need an all bells, all whistles inquiry to understand where the backlog is coming from. The tabloid headline is a once-in-a-generation review of the criminal justice system. It's over egging the pudding. What the problem is since 2016, there are roughly 22% fewer junior criminal barristers coming through the ranks. over the last 5 years, the number of what we used to call QCs, Queen's Counsel, they're now King's Counsel, has halved. And those King's Counsel would ordinarily become Crown Court judges. So we've got fewer junior barristers, fewer KCs, and fewer judges. That in the background of a decaying court system, court buildings. There are often times where I'm in the criminal courts and the courtrooms can't be used because the heating's not working. There's also a problem with the transport of prisoners. The Old Bailey, for example, sometimes it takes so long, the Central Criminal Court, the Old Bailey, sometimes it takes so long for prisoners to arrive. They're not getting there till midday, 1 o'clock. They should have been there in the morning. It knocks on the list of cases that are going to be dealt with that day. The prisoner ends up being transported back to the prison that they came from and the case being relisted for another day.
But why does it take so long? Can't you have a system where you bring the prisoners in at 8 o'clock in the morning, you hold them in cells in the Old Bailey, and then they're ready for the beginning of the court's business?
That's the perfect answer. That's the perfect solution. There's just not enough resources. There are just not enough.
Is this... of course, there is an argument the Conservatives in government didn't provide enough money, they cut back on legal aid, they didn't fund the criminal justice system properly, you then had COVID and got some backlogs. But when it's transporting prisoners, whether you get them there at 1 o'clock or you get them at 8 o'clock in the morning, it's surely organisational, not funding.
It is, but you can't really criticise when you look at the number of cases, you can't really criticise the last government because under that government, Crown Court cases came to an all-time low of around 30,000. They're now up near the 80,000s. COVID did have an impact, but it's continued after that. And I don't think you can put your finger on COVID or any
So we've gone from 30,000 Crown Court trials as a low to
cases in the system, the Crown Court system.
So there are 80,000, but they're not treating 80,000 in a year. That's why we've got the listings in 2027 and 2028 for some cases.
Yes. So, I mean, that's a very good point. There are cases where people are not in custody, where they're out on bail, and the Crown Court are kicking their cases into the long grass for later on into, 2027, which is outrageous.
And the Crown Court doesn't seem to sit for very long hours. Now, people say there's a lot of preparation that has to be done. But isn't the system just sort of fundamentally inefficient? Dare I say it, aren't the judges just a little bit idle?
Well, it's like you and Nigel were just talking about 4-day working weeks, but could you imagine if the judiciary worked a 4-day working week, how many more cases that we would have then? You know, a 4-day working week isn't very... What if journalists worked a 4-day working week? So we're not going to have news on a Friday, Saturday and Sunday. You know, it doesn't work, and it wouldn't work in the justice system. In fact, judges have been sitting at weekends to try and get through cases. But when you've got... I mean, one of the reasons there's so many cases in the Crown Court at the moment is because they are taking... If you're on bail, they're taking a long time, so they stay in the system, so the figures are inflated. It doesn't mean that bad criminals, you know, people that have done serious wrongs, aren't coming to justice quickly.
Because they're held on remand and there's a limit on how long people can be on remand before they're tried.
Well, there's roughly 90,000 people in prisons at the moment across this country, and there's about 3,000 vacant spaces at any one time. So there is not an unlimited number of prison cells. So if they are held on remand and we need to deal with them quickly, they are actually dealt with, they're not delayed. But if you're on bail, those sort of cases are heavily delayed.
And so what would you do other than limit jury trial to speed things up?
What would I do to speed up
to get through that backlog?
Well, you've got to, look, it starts at the very beginning. You've got to pay people a reasonable salary. You know, one of the reasons why there are fewer criminal barristers is they get paid so poorly compared to other lawyers in other professions. You know, we joke that not all lawyers are born equal, and it's quite true. A criminal defence lawyer will get paid a lot less. You know, for example, £60,000-70,000 in central London when they're 10 years post-qualified, whereas a corporate commercial lawyer would be looking at 6 figures starting with a 3, you know, in a decent firm. So the other professions within law are more attractive.
And so it's money, ultimately.
So we should attract more junior barristers. We should eventually get more criminal judges, and we should be looking at the courtrooms to make sure they are available to be sat so that judges can sit and deal with cases, as well as getting prisoners in on time. I think those small changes would sort out this backlog.
Paul, thank you very much
Thank you.
indeed. After the break, I'll be revealing why I'm supporting Labour for 15 minutes.